So what does it really mean that the FTC ruled today to enforce a non-compete ban nationwide? First of all, the rule doesn't go into effect for 120 days after it's published in the Federal Register. So we're talking probably 6 months from now, so maybe October of 2024, that it may take effect. Now, there's already business groups and organizations that are planning to sue to ban it or block it, saying they don't have the right to do it, or however they're going to, bring lawsuits against the FTC, the Federal Trade Commission, that is implementing this. Now, one thing that you have to understand, the rule, first of all, what it encumbers. Let's see. Let me share my screen to show you. All right, so this is what the FTC published. It's almost 600 pages, but that's because this contains all of the comments and background summaries that went into this that was proposed about a year ago, over a year ago. The actual rule is at the end. So the actual rule itself is pretty short. It starts somewhere up here. Here we go. Page 561. So rule concerning unfair methods of competition, that's the basis of it. So it covers business entities, partnerships, corporations, LLCs, and it deals only with employment. And a non-compete clause is a term or a clause of employment that prohibits a worker or penalizes them from seeking other work or operating a business, basically. So a non-compete would normally say, once you leave our employ and you can't work somewhere else that's a competing employer for a period of 2 years or something. And then you can't own a business that could potentially compete with us for a period of 5 years or whatever the terms are. Usually they're a couple of years, and there may be some geographical restrictions, like within 50 miles or in the state. And courts have interpreted that differently depending on the state, whether you can actually enforce a non-compete. Some states don't even allow them. So this doesn't necessarily change the way some states and courts interpret them. They interpret them in a very limited manner to protect employees anyways, but this is a general nationwide ban. So any private employer, and let's see. So it talks about an exclusion for certain higher paid executives making over $151,000 a year, where it may not apply. And also a worker is somebody who's paid, no matter what their title is. And under here, it says it does include independent contractors, or someone who provides a service to the person. So it's not necessarily, oh, it's only an employee. It could be someone who's a contractor, independent contractor, quote unquote 1099. It can still apply to them as well. It also can apply to a franchisee and franchisor. Now, what does it preclude? It says that you can't, other than senior executives, those higher paid people making over $151,000 a year, that you can't enter into a non-compete or try to enforce one or tell them that they're subject to a non-compete. Also, if there is an existing non-compete that you have for your employees, this section here says that you have to post a notice saying, essentially notifying workers that, by the way, the FTC issued a new rule and it bans non-compete, so you may not be subject to it anymore. Now, they actually have a form of the notice down here. This box right here says this is the form of the notice you should use to post at your workplace, saying that basically you can't enforce any non-compete clauses. You're no longer subject to it. So they've even shown you what the notice should look like. Now, there are some times where a non-compete does not apply, right here, exceptions. The bona fide sale of a business, that's pretty common. If you're selling a business, because you're selling an ownership interest, a lot of times you can enforce and put in a non-compete clause. Let's see. And also the federal rule does not, basically they talk about the state laws stay in effect. So if there's already, like, California is strict on non-competes already. So they're basically saying the new federal rule is not trying to go around the state rule. If the state rule is in effect and it's more restrictive, it stays in place. But the federal rule just gives a general guideline. So if there's an existing cause of action, then it's no longer included in the non-compete prohibition. Let's see. And that's about it. So it's a very short actual rule. It's only a couple pages long. And so it's probably going to have issues with being interpreted on who it applies to. But in general, it's pretty broad. And now, how are people going to deal with this? All right, so I do M&A work. So that's buying and selling businesses is part of what I do. And when you get into buying and selling a business, a lot of times you deal with non-compete provisions of the former owner, or enter into employment contracts for periods of time with non-competes. So usually, anytime you're dealing with a non-compete in an employment context, you have to kind of see what's going to be able to be enforced by the courts in the state where it may have to be enforced. And now you have to look at the federal rule as well. Basically, the way around that a lot of times is a non-solicitation. You cannot solicit our customers or solicit our employees to leave. Basically, don't steal our customers and don't steal our employees. That's not really a non-compete. So there's different case law on that, whether that could still be enforced. So that's one way still around it. The biggest one really is protection of trade secrets. So you can still protect confidential information of the business, even when an employee leaves or you sell the business, because those trade secrets, proprietary information, that could be anything like how we do business, processes, doesn't have to be a registered trademark or a patent. A trade secret can still be, anything kind of the secret sauce of this business or how we do it. That can still be protected. So even if there's a ban on a non-compete, you can still put protections in of your intellectual property. And that's usually the way people have been going around the non-compete ban, is to say, if you stay here and you've learned our special method for doing this process or sales or whatever it is, and our customer list and everything else, you cannot leave here, take our intellectual property, customer list, processes we use, what we've taught you, take that and go start a competing business with it, or go take it to a new employer. So it gets a little tricky, like, okay, well, what exactly are the trade secrets and how do we prove they're ours? How do we prove they're using them against us? But it is one way potentially to try to get around non-compete prohibitions by saying, well, you're still subject to trade secrets. And if you take our proprietary process, customer list, anything like that, and start a business and start competing with us, that's different than a non-compete of the employer or starting a competing business, because then you're using somebody else's intellectual property that you don't have the right to use. So it's kind of more of an intellectual property trade secret argument than a non-compete clause contractual argument. So that's one, like, those are a few ways around it: non-solicitation, trade secret protection. So we'll see. I have a feeling it's going to end up in court for a while, whether it goes into place or not. Also, there's a new administration potentially, depending on who wins the election, about the time that this is supposed to go into effect. That'll have a play in this, because the people pushing this are by the current administration and the people that they put in place. So obviously, if you have a more Democrat president and administration, and this is more of a employee protection to protect workers. So if you get a new administration in, they may not have that as the same priority, or at least view it the same way. So they may not push enforcement of this. So we'll see where it goes. Thanks for watching.